You want to do the private one at the end? No.
Good afternoon, Leader of the House, Chair of the Modernisation Committee. Thank you very much for coming before the Committee on Standards, your first appearance before the Committee on Standards. You are, of course, as I mentioned, Chair of the Modernisation Committee, which is a new committee. Do you want to just give a quick introduction, Chair, on what the Modernisation Committee is?
Absolutely, and thank you very much for having me today, and thank you to you, Alberto, and to all the members of this committee. I know all the lay members and yourself have served on this committee for a long time, and all the new members now of the committee that you've got as well. It's often a committee that does work that's not necessarily appreciated by everybody, but it's really, really important work, and I just wanted to thank everybody for their continued commitment to the committee. You'll be aware that we were elected as a new government on a manifesto of change and of restoring politics and public life to a politics of service. Part of that was about improving standards and working practices and how we governed, and we had a manifesto commitment to set up the Modernisation Committee to begin to make some of those changes, and that's really where the Modernisation Committee idea came from. You may remember a kind of predecessor version of that in the 1997 to 2010 Labour government, which at the time was more focused only on the sort of procedural aspect, because Parliament sort of and the Commons really needed to reform some of its procedures. We wanted to establish a modernisation committee for this era that was broader. Yes, at procedures, how we can work more effectively, the role of backbenchers, how that's changed, but also after that era really of the last few years that was blighted by sleaze and scandal and disrepute, about how we could help to raise standards and begin to restore some trust in politics. So that was the idea behind the Modernisation Committee. We set that up almost immediately after the election as a, as you'll know, as a government-chaired committee of the House, so as the predecessor committee was, which is a unique kind of model in this context. I've been really clear that I want the Modernisation Committee to not duplicate the work of other committees of the House, particularly this committee and the really important and unique role this committee has with lay members on it and everything else as well, but also the Procedures Committee, the Women and Equalities Committee, and so on. But that we felt that we needed a committee that could take a more strategic and holistic view about how all these different things interrelate with one another, and maybe look at things in the round. But also, having been a member myself for 12 years, I have seen on many, many occasions, and I know that this committee has seen this too, where very good recommendations and reports of committees go nowhere fast, and that the House of Commons sort of has sometimes a tendency to work at glacial pace, because if the government of the day doesn't want to take those recommendations forward, they don't proceed to the floor of the House or beyond that. So it was also about making me, as leader of the House, more accountable to the House for recommendations that come from committees like this, and chivying them along and making sure that they do then get taken forward. So I see it more as a task and finish group, if you like, or a sort of strategic body that will look at the work of all the committees of the House and how we can take those things forward, hopefully together and more quickly than has hitherto been the case.
Lovely, thank you. Can I turn to Gareth?
Hello, the Modernisation Committee, I think, has had several discussions about their interest, employment, what that might look like, and then what that might look like in further tightening. So I'm going to start the session by asking, why does the government in particular feel that further tightening of rules is around this? What's the in principle objection to MPs having outside interests? And really, what is the problem that you're actually hoping to solve by seeking to limit and reduce outside interests and second jobs, other earnings for members of Parliament outside this place?
Yeah, well, like you, I always try and not use the phrase second jobs. It's not my preferred phrase in that sense. But you will, we're all aware as members of Parliament that the reputation of MPs is very low. It has been, I would say, been getting lower over time, kind of not improved. That's certainly not been helped by a number of very high-profile cases over the last few years about misbehaviour or scandal, sleaze and so on. And this committee and others have looked into those issues, and this has sort of been iterative over time. You know, I'm not coming along here with a brand new idea. This committee has made recommendations and has been part of the process over the last few years to tighten the rules, to make outside lobbying, for example, in the wake of a previous sort of incident, to make that explicitly not permitted. And I think that we were all elected on a manifesto where we were really clear about the fact that we did need to turn the page on that era, and as a collective make sure that the reputation of MPs and of politicians was to begin to be restored, and issues of outside earnings, for example, has been the cause of one of those, of part of that sort of reduction in trust. And as I say, there was progress made on that over the recent years, and often that progress is only made because of there being one particular case or some incident that kind of takes that activity forward. We wanted to sort of take a bigger look at that. I just would emphasise, though, that obviously the 2 or 3 meetings that the Modernisation Committee has discussed some of these issues, Alberto has been present at those. That is how I would like to proceed. And I'm really hoping that as a result of our conversations today, you know, this committee will continue to take the lead on those issues, and you know, the Modernisation Committee will wait for you to consider that further. And as you'll know, as part of that, the Standards for Commissioner, who's here today, produced for me, both as leader and as chair of the Modernisation Committee, a very helpful note of advice about the options available to us. And,
that's fair. I mean, my question was sort of slightly different, because I understand the manifesto commitment on which the government was elected, and I understand the high-profile cases. I'm not entirely sure about the rules about who we can and can't mention in sort of previous cases, but obviously the most famous one being Owen Paterson and the issues there. Obviously, those exposed problems that have subsequently, in the initial works that have happened since the election, changed. So the lobbying, the parliamentary, those are now clearly prohibited. So I suppose what I'm trying to get is, what is the remaining problem that you think needs to be addressed? Does the government have an in-principle objection as a blanket of members of Parliament having external activities and external earnings? And you talked about the reputation of members of Parliament and politics being low. I suppose I'm curious as to whether you think there's a fair representation and a fair public consideration of the work that we do and not. And if it isn't, if you don't believe it to be a fair representation of what we do, how does changing the rules address that? And are we not potentially trying to solve a problem that actually is more of a messaging issue than an ethics and conduct issue?
Well, look, I think you make a really good point. Look, if you canvass the public, they probably all want us to do the job of being an MP for no pay, taking up all of our time, and you know, frankly, sort of probably living in a dustbin while we were doing it, and that would maybe satisfy that sort of public appetite. So I totally sort of get your point, but I think, look, there are some who think that we should do an outright ban on members of Parliament having any outside sort of interests or additional earnings. There are others who think that MPs should just self-govern that completely themselves and then leave it to their constituents once every 4 or 5 years to determine whether they felt they sort of gave the job sort of sufficient attention or whether there are any conflicts of interest. I don't take either of those views, and I think we have been exploring, and as you say, there have been tightening of the rules around that sort of middle ground. So in the first instance, obviously in 2022, sort of tightening the rules around lobbying, for which there were then 3 exemptions within that, whether you were giving advice on policy, whether you were giving advice on how Parliament works, or whether you were undertaking media or other work. Straight after the election, I felt those exemptions were too broad. I think that that they were too broad. They allowed potentially a lot of these kind of areas of work to continue within that the rules weren't intending to do. So we laid before the House a motion to withdraw those two of those exemptions. We've left the third. I think that thinking about that third is something I hope this committee would consider. And then I've been very taken with the advice from the Standards Commissioner around looking at a principle-based approach now about how we can just be even clearer about the intention and purpose of those rules and what kind of outside interests are or aren't of interest. I do share the view that many hold that having members of Parliament who are also lawyers or doctors or who have business interests, businesses that they previously held before coming to Parliament, I think that adds to the House as a whole in terms of that expertise, which is why I don't think that producing a list of permitted sort of jobs or careers sort of is particularly effective. I think we're going to get into that specific. Okay, that's fine. Yeah, so that I think that's so. Look, I think these things are a balance. We have over time, this is not a year dot thing. That's the point I want to make. This committee has led the way, in fact, over the last few years in refining those rules. But I do think there's a case for doing that further.
Thank you. Thanks, Leader Gall.
Yes, sorry.
Melanie.
Thank you. I just wanted to follow up really on that question about the tightening of the rules, Leader. And do you see any potential risks with rules being tightened, perhaps an increase in people falling foul of some of the rules at an increasing level and thereby doing the exact opposite as more people fall foul of rules, that perhaps public perception says actually they're all at it and it doing completely the opposite to what you intended to do?
Well, look, I think that's always the balance to be struck here. I personally feel that rules are our friend in these situations because then it helps to guide our own sort of activity rather than, I think, what we've seen over time in the past, which is there's a scandal or there's an occurrence and then there's a clamour to kind of tighten the rules after the fact that then sort of catches people out, if you like, retrospectively or whatever. So I think a kind of sober look at that in advance, because there were loads of more stories about that this weekend. There are stories all the time about the nature and the quantum of sort of outside earnings for members of Parliament and whether that's appropriate or not. And I think, I think looking at some of the principles around that, which is around conflict of interest and whether you are specifically sort of monetising your position as a member of Parliament in order to gain that additional income. I think those sorts of principles are really good ones on which we can rest to help members take those decisions, because it's not going to go away just because we don't tighten the rules. We're still going to be scrutinised, as we are, rightly I think, all the time, about whether the behaviour of a small number of individuals tar us all with the same brush when those individuals or others are seen to be gaming the system and monetising their role as a member, or engage with something that any ordinary member of the public might perceive as being a conflict of interest.
So you see this as getting ahead of the game and setting a framework to last far into the future?
I do, and also building on, I think, the very good work that's happened over the last few years in kind of addressing some of those issues in response to sort of previous incidents as well.
Thank you.
Thank you, Melanie. Paula.
Morning, Lisa. You sent an initial memorandum to the Modernisation Committee and basically asked for them to consider what advantages, if any, there were of paid engagements, such as media appearances, journalism and speeches, and what benefits, if any, that brought to the public. I'd just be interested to understand if you have identified any advantages so far.
Well, as I say, we've had some very top level initial discussions, and I'm really hoping that actually, you know, the detail of that would be considered by this committee, and so we wouldn't consider that further. But as I say, the thing about media appearances, speech and so on is partly because it remains as one of the exemptions under the sort of paid roles, so it was sort of stress testing the appropriateness of that, and sort of additionally or in parallel to that, I think the issue that is of potential reputational concern for the House as a whole is where there are paid ongoing employment contracts with media organisations and other organisations where they could give rise to a perceived conflict of interest, or whether they could give rise to this perception that someone is monetising their position as a member of Parliament. So kind of more specific sort of area within that. So kind of the principles, if you like, applying to that space. What I'm really not talking about of course, is how important it is for us as members of Parliament and politicians to be able to communicate with the public and our constituents via the media and via the forums of the media. There is obviously sort of considerations there around free speech as well, which of course we should be very alive to. But I think it's the more specific cases where people have paid contracts of employment, essentially, whether they be with media organisations or others, that could give rise, where we're responsible as a house for media policy, for example, could give rise to conflicts of interest, or could give rise to the sense that additional income has been given because you are a member of Parliament, therefore monetising your position as an MP. So it's that sort of specific area.
Okay,
I think Gareth's got a follow-up question. Thank you, Paula.
You said there that the conflict of interest could be perceived to be arised if you have a media show, or if you are in a contract of employment for media, because the House, the Parliament, is responsible for media policy. We're also responsible for regulating health policy, and we're responsible for the law, we're responsible for business regulation. So why would you draw a distinction, as you said earlier, that lawyers, doctors, businesses enriches the House, but people that may have media appearances would be subject to a different standard?
Well, under the rules around paid advocacy, as I say, there were...
Not advocacy, this is about, you were saying...
Well, paid employment, that where you were giving policy advice. So if you had a contract of employment with a health company and you were giving policy advice, that would no longer be, that would no longer, that would, no, you're confusing two things. I said you would no longer be able to give health policy advice, okay? If you had a paid contract of employment and you would be no longer be able to give advice about the passing of legislation or how Parliament works, that would no longer be permitted, which it was up until recently. It would now no longer be permitted. But what is still permitted under that same rule is around media, book writing, speeches and so on, as an exemption to that rule. So that loophole, if you like, remains where it doesn't remain for the others. So your previous work or your work as a doctor or as a lawyer is not connected to that paid employment in relation to that rule. So that's why it's specifically mentioned on its own. And as I say, I mean, I'd like this committee to really sort of drill down on that. But if there was a big, and often there is a big point of public policy in relation to a media organisation, a competitor media organisation, or indeed a media organisation under which a member of this House had a paid role, would that give a perception of conflict of interest and not be able to carry out their job fairly?
Okay, I've got follow-up from Paula and then Mel, and then I'll move on to the next question, if I can, please.
I suppose just for a point of clarity, and so the public are aware as well about the thought processes around this, because I completely concur with you that, you know, the public perception of parliamentarians is not probably the most positive of professions. And you spoke about things that could potentially bring the House into disrepute. We spoke about conflicts of interest, and you have outlined certain professions that perhaps people need to do so many hours to maintain professional registration, for example, such as doctors, nurses. You also spoke about lawyers, for example, and I understand that they may be of that profession before they come into the House, and sometimes being a parliamentarian can be short-lived, sadly.
Absolutely, yeah.
So obviously that is something to consider as well. Obviously they're not giving policy advice, etc., but sometimes, you know, there's been cases in the media recently in terms of health service, and a specific case which obviously I won't go into. But it would be possible that a doctor or a nurse or whatever could be involved in a case such as that. What's your views on potential conflicts there and potential disrepute to the House in cases such as that?
Well, obviously, you would have to declare in contributing to any debate or anything else that you were also a doctor or a nurse, or that you had a family business or whatever. So look, I mean, we're not going, as I say, we can completely rule out any sort of problems by just doing a complete blanket ban, right? I really don't think that is in everybody's interest, or would be effective to do that in this context, for all the reasons that you say and that others say. So it's how do we best take forward, I think, tightening the rules in such a way that there wouldn't be a perception that there's still means by which people can sort of get around it, and we still have, you know, a myriad of sort of stories where we have some of these issues. And I've thought at great length about whether producing a list of professions, whether putting a cap on monetary value, or whether considering a cap on hours or something like that. I think, you know, and obviously the extensive conversations that I've had sort of privately, but also the Modernisation Committee has had with the Commissioner, you know, led me to the conclusion that they all have much bigger pitfalls and problems in terms of policing and really overseeing that, to get exhaustive amounts or appropriate or reasonable things, than going down a principled-based approach. And as I say, would that mean that someone who was a lawyer as well as being a member of Parliament could earn a lot of money and spend a lot of time providing legal advice? Well, yes, they could. Could somebody who was who already had a media contract, for example, before they were elected, under these sort of principles, could they then continue that afterwards? Well, probably they could, because they would argue that they've not monetised being an MP. Absolutely. Unless you take the view that the conflict of interest is a greater concern in that situation. So there are still going to be sort of situations, but I think we do need to explore going further, because I think the exemption as it currently exists, and the rules as they currently exist have too many incidents of public perception of conflict of interest and people getting extra earnings because they are a member of Parliament, and that in itself tars us all with the same brush.
So mindful
Sorry,
of time.
I know,
Not at all. We've
I'll
got
be
lots
shorter.
of questions. Not at all. We've got lots of questions. I'm going to take Mel, and then I'm going to move to David.
If your principal concern is around media, is this not something that is better solved in beefing up Ofcom's rules and having exemptions that way?
My principal concern isn't media, actually. I think that is one area, and it's partly because, as I say, we had 3 exemptions to the previous rules, and 2 of those exemptions we've now taken out, so it still leaves it. So I think it does need exploring whether that's appropriate. But the perception of the media in writing up my views are that I'm interested in the media, but that's the media's obsession with itself, I would say. But there are other issues there that are for other regulators, as you say, about the appropriateness or otherwise of politicians more than members of Parliament, senior politicians who by their very nature, we have partisan views. That's what makes us politicians, not civil servants. Being touted as news broadcasters. I mean, that is an issue for Ofcom. That's not my interest. My interest here is about the reputational risk to the House of people having potentially conflicts of interest or being seen to be gaming the system for their own personal gain, and therefore tarring the reputation of us all.
Thank you, Leader. David.
Thank you. Your comments around monetising the position are actually, I think, quite helpful. I perhaps counter your description of the public perception of MPs wanting you to live in poverty in a dustbin. I, as a lay member on this committee, don't believe that that's my view. I would personally welcome if we were able to pay the heating in this room, for instance.
Yes, so would I.
That would be great.
It's cold.
You've addressed 2 issues in your comments. One is around earnings and how they might be seen as either that monetisation or providing an undue influence to MPs. To some extent, we can address that by the Register of Interests and by declaration and by our prohibition on lobbying. But the other one around the attention or the time commitments is a bigger issue.
It is.
And I think that's where I would suggest there is a considerable public interest in how much time is being taken up in these external interests, and can that be justified? I wonder what your thoughts on that were.
Yeah, and I think, look, so there were 3 principles which the Commissioner suggested as a starting point. One was around that conflict of attention, which actually I think was probably my phrase initially, which he's taken and put into that. The second was around a conflict of interest, which we've mentioned, and then the third is about whether someone could reasonably perceive that you were given that paid employment or earnings because you were a member of Parliament. I do recognise that the first of those, around the conflict of attention, is probably the most pertinent for the public and probably the most inherently difficult and complicated for us to actually design or police, and you could argue would lead you to a position where there was no amount of anything else you could do that would possibly kind of live up to that principle. So I think you're absolutely right to alight upon the one that is probably the most challenging, but perhaps the one that people would have the highest expectation of.
And it's often not necessarily around employment. Some fairly recent cases come to mind of people absenting themselves both from Parliament, both from the House and from the constituency work for prolonged periods of time. We also have situations, you may have picked up from my accent, situations in Scotland where people are a member of both this House and Holyrood. And I wonder what your views were on that sort of wider piece of effectively multiple full-time employments.
Well, I mean, they are difficult, but you know, I think obviously the move is a move away from that. I think somebody maybe not too far from where you're talking about who was planning on sort of holding both positions, the sort of public outcry was such that then they sort of decided not to do that. I mean, look, I'm a minister as well as being a member of Parliament, and you could argue that my constituents are less well served by me being a minister as well, because I therefore am not spending all of my time on constituency matters or raising sort of constituency matters. So these are kind of complex areas because we are not employees, we don't have a job description, and how we determine the most effective way of representing our constituents or doing our job is something that we all have to work out for ourselves to some degree, and we all put greater emphasis or less on some aspects of that. You know, some colleagues take their role as national parliamentarians or as scrutineers of government policy, you know, incredibly seriously. Others will take constituency casework as being their main their main function. But yeah, I mean, there obviously are challenges, and a number of colleagues at the moment are still councillors because they were elected sort of very quickly or unexpectedly in many cases, and are still councillors and they're waiting for the next set of elections to happen. So, you know, I think we do have to have some slack in the system around that rather than necessarily encouraging it or allowing it. But some people aren't MPs for very long either.
Yes, thank you.
Thank you. Michael, did you want to come in at this point?
I'm Michael Brown, member of the committee. Just want to pick up on a couple of issues you raised in your opening statement around duplication and reports going nowhere. The first relates to the Modernisation Committee looking at ICGS. That's also something that this committee is looking at, and indeed we're asking Gail Walton to give evidence to us.
Great.
How do we avoid that degree of overlap and duplication in relation to that?
Well, I mean, I think by obviously keeping in close conversation, the Modernisation Committee is looking at a very specific recommendation that came out of the Kernahan review that was published just before the election into the ICGS. And many of those recommendations either are for this committee or they're for the House Commission or they're for others to consider. There was one recommendation about the relationship between the ICGS and the party disciplinary systems, and where you know, victims in particular have found that confusing sometimes, and there's not necessarily been the sort of sharing of information and things. So the recommendation was that there would be a memorandum of understanding between the party whips, if you like, and the ICGS. That's a very, very difficult recommendation to consider how that might be taken forward, and there's very strong views on that. So the Modernisation Committee, we've got a sort of small working group, because we do have the benefit on our committee of also having representatives of the three main parties' whips on the Modernisation Committee, that they are sort of taking that forward with Thea, and Thea was actually very grateful that there was a place that maybe that now could be taken forward. So I don't think, I mean, tell me if I'm wrong, that would overlap too much with some of the areas that you wanted to look at, but I would, you know, as sort of leader of the House, if you like, as well as the sort of chair of the Modernisation Committee, I would strongly welcome, you know, looking at any recommendations you might have about the ICGS, which I think has been a really important development over recent years in making this place a safer place for people to work, and rooting out bad behaviour and bullying and harassment and sexual harassment, and that still exists, I'm afraid, in the parliamentary community, but it's now, I think, a smaller issue than it once was. But I'm a strong believer in the ICGS and the work that it does, and I'm happy to work with you on how that could be strengthened.
I think that's very helpful, and certainly I can see opportunities where we're both looking at different things in this regard, so that's been a very helpful response. The second issue relates to the landscape review that we did in the previous government. And you say in your response, the government will in future publish a register of ministers' interests.
Could I interrupt? Sorry, could I suggest that we keep that for the private session that's
okay,
coming?
Fine.
Forgive me, Michael.
Okay.
Can I move on, as I'm very mindful of time? Can I move on to Rosemary, please?
Thank you.
Thank you.
Good afternoon, I suppose it's now, leader. Thank you. I'm Rosemary Parr, a lay member of this committee as well. And in many ways, you've already touched on your answers around why you think the rules, or our current rules and contract around what we have done and how they've recently been tightened, do not go far enough. And we've spoken about MPs who are perhaps doctors or nurses who also may want to keep their revalidation purposes. And I suppose if further tightening of the rules, do you think it might lead to decreasing the diversity of the House? How would you think about having that maybe a thing that might actually be a negative consequence of further tightening the rules, that we don't get that diversity that we have already for our MPs?
Well, absolutely. I think that's part of where the balance needs to be struck, because I think sort of we don't want a House of Commons of, I mean, I sort of say this, I'm often kind of categorised as one myself, but of sort of career politicians, if you like, or people that have always been on that sort of route or whatever. I think we live in a more febrile political context as well. I think we've seen a huge changeover at this election, over 350 new MPs, the biggest ever. I think that level of churn, maybe not quite at that level, but we will see that over time, and what that gives you are people who didn't expect to be members of Parliament, people who are sort of standing and then suddenly find themselves as member of Parliament. It also gives you shorter parliamentary careers. I said this earlier today to the Modernisation Committee. I was one of the last people to speak in the last Parliament, responding to the valedictory speeches. And I remember thinking to myself, I think this era of these great parliamentarians with 30, 40, 50-year careers behind them that I was speaking about, I think that era is behind us. It's not in front of us. And so we do need to see this more in the context of people having a sort of shorter career as a member of Parliament alongside a sort of, and it's the world of work, it's changing anyway in that way, isn't it? Where it's one career of many that people might have. So we don't want to sort of throw the baby out with the bathwater. And, that's why I have been sort of quite taken with those principles, because I think that helps us, in that regard, notwithstanding maybe, as we discussed, David raised with me, I think that first principle, does that maybe rule out too many things? And I think that would be, I'd be really grateful for your advice on that, really.
Thank you.
Thank you, Mark.
Thank you, Chair. Thank you, Leader. You've indicated support for, and I'm quoting here, qualified prohibition on paid outside interests following a principles-based approach. Can we dig a little bit more into that? Because you've talked about some of those that might have been that might be outside of the scope of that, but can we talk a little bit more about what might be within the scope of that?
For example, I think what I don't know that. I think the whole kind of point of it is to not get to the specifics, because in a sense that's what a principle-based approach gives you, and the Commissioner has outlined, I think, some very helpful starting points of principles. But I would really very much welcome this committee considering whether those principles are the right ones, how those principles might translate into being enforced or the actual fact of them, and whether they would have the desired intention or indeed the wrong intention when it came to sort of certain specific examples. So, I don't want to sit here now in sort of judge and jury of this particular case, that particular circumstance. And as I say, I think a principle-based approach, sitting on top of the rules that already exist, would just help clarify that further and help to begin this journey of sort of restoring some trust and faith in MPs and politicians.
Following up on that and coming back to what you said earlier, you've been clear that you believe that an absolute prohibition on outside employment is not the preferred approach, and you've referenced, for example, those who require professional registration, for example, would be excluded. It seems to me, as a member of Parliament, that it's a pretty, even to call it a full-time job is a pretty stretching definition of what a full-time job is. Why wouldn't we just prohibit all of those except those who require professional registration? And on professional registration, one of the issues that's been discussed here is conflict of interest. Members of Parliament or legislators write and vote on laws as their job. How can you be a lawyer determining what law means if you are also writing laws? How is that not a conflict of interest?
Well, to your first point, I mean, look, it's not a full-time job, it's a way of life. We're office holders, you know, we are, this is a sort of commitment to our constituents, to our country that there are no boundaries to. We all know that. I'm never not a member of Parliament. I'm kind of never not at work, really. You know, I always remember when, I actually arrived here pregnant, but 2 days after my son was born, I needed to deal with something that only I could deal with as the Member of Parliament. And there I was with a 2-year-old baby in my arms dealing with that in the office. And that we all know that's what the nature of this is. We aren't employees, you know, we aren't workers, we are office holders, and we do that. I think that when you drill down into this, what does exemptions mean? I mean, and that's really, I think, where we're all kind of sitting, is that we recognise there are some exemptions. Do you go down the route of kind of writing up what that list is? Is that the fair way of doing that? What does that mean in relation to, let's say, someone who has a business when they arrive here? Do they have to, you know, within a matter of weeks, completely divest themselves of that business or whatever? You know, so it's not just professional qualifications. There are other examples that I think we could all reasonably accept were sort of reasonable for someone to retain through their time as an MP. And when you try to actually draw up that list, it's impossible to make it exhaustive and appropriate. You will always find things that actually then, with hindsight, you can reasonably sort of suggest should have been on that list in the first place. And that's why I've arrived at the idea of a principle-based approach on that, because I think that does the job for you without getting you to a difficult place of, well, is this okay? Is somebody who's a councillor, but they're only going to be a councillor for 6 months, is that okay or not okay? Is this person who's got a business that they, you know, are getting somebody else to run, but they're going to sort of retain an interest in because they've been elected with a majority of 100 on a, you know, and they're not expecting to be here within 4 years' time or something. Do you know what I mean? So that's why I've sort of arrived at that, because I think if you look at other options like a cap on earnings or a cap on hours or a list, I think they all have inherent problems that you have a lot of unintended consequences. What was your second point? Sorry.
In regard to conflict of interest.
Yeah.
So, for example, a lawyer was one of the, I think everyone would agree that lawyers have and continue to contribute a great deal to the work of this place. But if we're talking about, you know, trying to avoid a perceived conflict of interest, if you're writing laws and you're interpreting laws and you're using your knowledge of those laws gained perhaps in this place to interpret them, is that not a conflict of interest?
Well, look, I think this gets back to that question about whether we think that the House as a whole benefits from having a range of expertise in it, and people with, you know, a range of previous experience and, you know, in some cases sort of current experience of the things that we are looking at. And I personally think that the House does benefit from that, and we don't want to get to a situation where people in other professions or other industries or whatever are put off from coming here because of some of these restrictions perhaps feeling overbearing or not being for them in the long term. Then the House, I think, loses that level of expertise, and we all bring expertise from our previous careers, from our current constituent. You know, I've developed expertise in all sorts of things that are very pertinent to Manchester Central, for example. I'm also married to a doctor, so, you know, I am effectively lobbied most days about the state of A&E, for example. But so we should all bring our collective knowledge and experience. What we absolutely don't think is appropriate and brings with it a reputational risk is where people are getting additional money for bringing that so-called expertise or those interests to this house, and that is something that obviously we've sought to eliminate.
I'm very mindful of
I'm sorry,
time.
but I will be
not
shorter.
at all. Going to have Gareth and then Neil, followed by Anna.
It kind of follows up from the question from Mark, that the last Code of Conduct review, the committee concluded against introducing restrictions around MPs, and they use the term second jobs, though I don't like that term, which potentially could require the Commissioner to make subjective judgments about how MPs should spend their time. So do you have any concerns that a principle-based approach would put the Commissioner into that situation? If you don't, who would you see as being the arbiter of whether a principle had been broken or not? And in the manifesto, in the Labour Party manifesto, which you referred to earlier, it says we will establish a modernisation committee to take forward urgent work on the restrictions that need to be put in place to prevent MPs from, and this is the important bit, taking up roles that stop them serving their constituents and their country. I'd be really interested to understand, Leader, what specific actions you think members of Parliament need to do in order to satisfy the clause of serving their constituents and their country in relation to activities in this House.
Yeah, so to your first point, I think this is a really important question, and one which this committee has considered, on a number of occasions, and will, I'm sure, continue to do that. And I think the role of the Commissioner and his, and it may at some point in the future be his relationship with this committee is obviously a matter for this committee and the House more broadly. And I think the approach that was previously arrived at, I think, is the right one, where the Commissioner investigates alleged breaches of the code, whether they be the code as it currently exists or one that takes into account further principles. And in essence, the code it has got some amount of subjectivity to that to some degree, and that's the role of the Commissioner in relationship to then bringing that to this committee, and it's for this committee to then consider that further and properly, and that should a member and that's where the sort of safe harbour provisions come in, which I think are really important as well. That obviously any member can go to the registrar and seek advice about that, and where they are acting on that advice, that gives them sort of safe harbour around some of those provisions, and that be sort of considered going forward. So I think I see this very much continuing with what this committee sort of re-established, really, if you like, in that previous consideration, and continuing in that vein. But to your broader point, I mean, look, it's these are sort of perceptions that people have about the behaviour of MPs and all of that kind of thing. And as I say, you can we can go down. We could go down a route where there were no exemptions at all, and there was just a complete blanket sort of ban on anything like this at all. Would that enable us to do our job, most effectively? Is that the sort of fair and proportionate sort of outcome? And I don't think it is. But that's why a principle-based approach is the one.
I understand that. I think the question I was trying to get, and apologies, Chair, that I wasn't clear in explaining that is, even with a principle-based system, somebody has to be the arbiter of whether or not a principle has been breached. And if part of the principle is restoring faith and trust in politics, i.e. politicians aren't working hard enough, politicians are on the take, politicians are attempting to subvert the system for personal financial gain, then somebody, potentially it is the Commissioner, potentially it isn't, has to look at a case. And you said earlier that there are pre-existing examples where lawyers in this place can earn lots of money,
but that wouldn't be
spend lots of hours working on that, and that wouldn't be covered by these principles-based system now. So if I were to say, you know, I'm trying to get to the bottom of what is it that you foresee as being sufficiently detrimental to the work of a Member of Parliament that it restricts what they do to the point that it would breach a principle that could therefore be damaging to politics? Is it, you know, how many times I'm voting, how many times I'm speaking? Is it the volume of casework that I do? And if it is that, who becomes the arbiter of this much speaking and this many participation divisions means you are serving your constituents, fewer than this means you're not, and we would attribute that because you have this external activity that is distracting you from the responsibilities that you have in this House. Where does that all come together? Because whilst I understand the principle-based approach, the practicality is to enforce it, you have to have some sort of yardstick against which you are judging people's actions to determine whether they're in compliance or not.
Yes, so look, so we're not talking about a principle that is a principle that you just described. We're talking about specific principles as advised by the Commissioner himself, therefore feeling that they would be policeable and enforceable, because absolutely they have to be. And I think of all members of the committee got a copy of that note, yeah, which I don't know if will be, if you will choose to publish that or not. It's something we can perhaps discuss later. But they have to be logical principles. They have to, I'm just reading from that note, derive from, relate to the Nolan principles, articulated in a clear and simple form that can be easily understood and appreciated by everybody. And they should be capable of being implemented robustly and effectively. And I think that's a really good guide. Based on that, the Commissioner's suggestion for 3 principles for us to consider as to whether they would give the outcome that we desire would be, the first would be a principle around paying full attention to their parliamentary responsibilities. Now, I agree with you that I think that is the most contestable and difficult of the 3 principles. And I hope this committee will really consider that.
I'm interested in how you would define that, though, because we will have our discussions.
I actually think that probably is the hardest of the 3 to say that we would do, because of those reasons. But I think the second and third principles, I think, are really clear, understandable, and what I would hope you would really focus on as a committee, which is the second of which is around a potential conflict of interest, which I think is sort of well understood sort of principle for standards, and the third being around whether members are expected or a reasonable observer about being made that the offers of paid employment or outside interest are primarily because of their membership of this House. So effectively, to the point I was making earlier about monetising your role as a Member of Parliament. And yes, of course, there are some bits of subjectivity. Every consideration, I'm sure every case that you consider as a Standards Committee, there is some degree of subjectivity to them. And that is why we have the sort of checks and balances that we have in these things, which is determination and consideration by a commissioner, further determination and consideration by this committee, and in some cases, in other forums, we have the independent expert panel and so on that do that. But I do agree that the first of those possible principles, and these were just examples, I'm sure that you've discussed this and you would discuss this with the Commissioner, these were examples of the types of principles we could consider. I agree that the first of those is probably the most difficult, but as David said, probably the one that the public would deem as the most important, and I think that's hopefully a really, if you're up for it and you want to kind of look at these things, I would just be incredibly grateful for your advice and your recommendations.
Can I make a suggestion? Because I think Gareth has hit the nail on the head with many of these, and I've noticed the Commissioner nodding, and I've read his very helpful advice note. Actually, it will all be determined on the other evidence that we obtain. It will be for this committee then to maybe ask supplementary questions of you to understand what conflict of attention actually means and things like that. So I think Gareth has asked some very pertinent questions which will go to the heart of whatever we determine as a committee and then make recommendations. But if you'd be willing...
Exactly, and I think conflict of attention potentially does lead to the prohibition of,
no, I think
of everything.
we understand
yeah.
the generalities, but I probably will come back to you with specific questions as we gain further stakeholder evidence, if that's okay. I am very mindful of time, and I know that Neil and Anna and Francis have got some questions to ask. I'm very grateful that we are running slightly over, but I'm very grateful for your time. So if I can turn to Neil, then Anna and Francis.
You've been very clear in your preference for a principles-based system, and you've set out in your last answer proposed principles that were provided by the Commissioner. What assessment, if any, has been made as to the breadth and range of paid outside interests that would be captured by those principle-based system?
Well, I think it's in addition to the rules, by the way. So not to replace the current code, but to overlay that code, if you like, sort of further advice around that code. Just to be clear, I'm not talking about we sort of throw away all the current rules and then replace it with principles. And I think, as I say, I think it's you've got to be kind of careful not to design the rules around particular cases or around trying to sort of catch particular behaviour. They have to stand the sort of test of time and be reasonable in that sense. We have, I mean, because the expectation was that the Labour Party, as it stood, still are the Labour Party, the opposition at the time were likely to win the last election, and we had sort of policies around sort of tightening these. We have seen MPs sort of changing their behaviour over that time. In fact, I think there were, some MPs sort of stood down from Parliament because of that. And then actually what we've done has perhaps not been as widespread as some feared. So we took away the exemptions in July, and I wanted to make sure that MPs had time to readjust their affairs. So they became operational at the end of October. It gave everybody sort of 3 months to kind of move around that. I mean, I don't sort of look at this in detail, but I have noticed that some MPs have reduced some of their outside earnings over that time, around those particular areas.
To the changes that were made before, not just economic circumstances, personal lifestyle changes, anything that you can link to that rule change leading to that reduction?
I think probably there were, a couple.
Do you have any evidence? I'm not asking.
Well, I don't want to talk about sort of specific
we
cases.
can come back to this, because I think Gareth, you're going to be very helpful in drafting some questions that we will drill back down. But if we go, I think you've more or less answered Neil's question. Is it?
Yes, it was just one follow-up, if I may, Chair, which was around, these principles are of course based upon paid outside interests, but there can be unpaid outside interests that also detract potentially from work in this place. What consideration has been made of those?
Well, I mean, you make a good point, and obviously the kind of work that people might do as volunteers or for charity or for other things, but that's why I focus mainly what I'm proposing on the conflict of interest and on monetising your role as an MP as being the things that I think are the most sort of problematic, and that things that we do in a voluntary capacity do add to, can add to people's sort of expertise, and they're not seen as personal gain in the same way as where there is a conflict of interest or where you are taking monetary payment for what you're doing.
Okay, thank you. Anna and Francis, it's again about principles based, so we've sort of covered some of these, but again, if we could have short answers.
I will
later. Thank
try
you.
my best.
Anna.
So the Commissioner's suggested principles include an expectation that members don't accept offers of paid outside interest that might detract or appear to detract from their ability to pay full attention to their parliamentary responsibilities. And I guess I'm wondering what kind of external role wouldn't detract from that, because I can think of, and I'm particularly interested in this role about doctors. Doctors are always used as an example of a kind of good thing to have in Parliament, and they must, them going out to work is helpful, but actually being a doctor might significantly detract from your role as an MP.
Yeah, and I think that is, as I said before, I think that is why that one is challenging, and they are, as Gareth was sort of saying, does me having 3 children sort of detract from me being a effective MP. I would argue, obviously, sort of not. But of course, we all have things in our life, that caring responsibilities or other challenges where we have to kind of juggle all of these things. But the role that we have, and it's not quite related to your point, but we are not paid employees that are doing sort of 39 or 40 hours a week, sort of clocking on, clocking off, and then we kind of go and are in a choir in the evening, or go and work in a bar or something in the evening to supplement our income. We are office holders, we are members of Parliament, and I think most of us would all agree that we are never not members of Parliament, and that the distinction between one aspect of our lives and another aspect of our lives and being an MP is incredibly blurred. There's sort of no point at which we're not kind of juggling all of those things at once. So we do need to think about that in the round.
Thank you, Francis. Very briefly, I think again we've covered more of these, but over to you.
Can I ask just a point of clarification?
Yes,
sure.
Of course, please. Yes,
because earlier on, you mentioned that there might be occasions where an individual had been in some sort of paid interest beforehand and then didn't fall foul of the rules because actually they were already doing that job. Maybe it was a media or a lawyer's. But then later on, you talked about somebody who has a business and maybe they had to divest themselves of that business over a period, and that would be reasonable within the principles. So my question really is do you think that actually when somebody becomes an MP, actually the time starts afresh and they should review all of their paid interest as to whether they fit within the principles or not? And the fact that they have done it before is largely irrelevant, because actually it's more about then reassessing whether that paid interest fits with the principles, not that actually they happen to have done it before, because there's both a reality and a perception of this.
Well, of course, I mean, look, I think there's obviously clear rules already about the nature of paid work, and declaring that and being fully transparent about that, and then overlaying that with some further principles, of which these three are examples, not necessarily. So I was given an example that under that particular principle, the third principle of whether a reasonable observer or someone might think that you were given that paid employment because you were a member of Parliament, you could argue that somebody who was doing it beforehand could continue doing that. Now, whether that's the judgment they should make at that time, and they're obviously, at the heart of this whole sort of standards landscape is a certain degree of sort of self-governance and self-judgment about that, even in this context. I can get away with it, so therefore I'm going to continue doing it. I could just about get away with it, so I'm going to continue doing it, versus obviously should they make a judgment that they've got another job to do now and they've got other stuff to do, is obviously a matter for them. But I think what we need to explore is how we can ensure that has sufficient guardrails around it, around the key principles that we think people should be subjecting those decisions to, around conflict of interest, around sort of monetising their sort of position, and potentially this conflict of attention, which I accept is a much more challenging one to consider and might be for a future sort of date. But and I know, people make those decisions all the time, whether they're a councillor or perhaps another office holder, whether they've got a business. Sometimes people make the decision, I'll stop doing that in a few months' time because it's sort of more complicated to try and stop being a councillor immediately or something, or there's other reasons why not. Or if they've got a business, they're not able to get someone else to quickly come in and run it for them. They weren't expecting to be a member of Parliament, but over time they realise they just really, really can't. So you wouldn't want to kind of get people falling foul of rules for those sorts of reasons. And that's why I think that is a good principle to consider, because I think that gives that flexibility. But of course there is an element of quite a large element of self-judgment about that.
Okay, that concludes the public session.
Thank you.
Order, order.